Hey y'all, we're back with another common misconception. Today we're going to answer the question of whether you can remove someone's name from a deed that is related to a piece of real estate property. My name is Whitney Thomas. I'm a Texas estate planning, probate, and guardianship attorney, and I'm the owner of the Whitney Thomas Law Firm in San Antonio, Texas. It's important to note that estate planning, probate, and guardianship are statutory laws. This means the law surrounding these areas changes from state to state. I'm a Texas lawyer, so I can only provide general information about Texas law. So when I sit down and have a consultation with a potential client, I'm very rarely asked, hey, can you help me with a probate for a loved one who's passed away? Usually I'm asked the question or asked for assistance in a more practical matter, and they'll ask me, hey, my loved one has passed away. Can you help me remove their name from the deed on the house? And unfortunately, my answer is always going to be no. But the reason why is because you can't remove someone's name from a deed. And let me tell you why. When someone owns a house and they convey the house, that means pass title, whether it's through selling the house or if they decide to gift the house to someone, there generally has to be a deed created. And that deed is written evidence of how the ownership of that property passes. So every time the property's passed, there has to be a deed. If property owner A owns the house, they sell it, they'll create a deed conveying that property to person B. If person B owns the house and decides to give it to a relative, then they would convey a deed that says, I'm giving this house to a relative. Once the deeds are executed, then they are taken to the county property records where the property is located, and they're filed with the county clerk. And that's how you put everybody on notice that the ownership of this property belongs to whoever's listed on the deed. So you may go to a title company when you're ready to sell a property that you believe that you own, and that title company may tell you, hey, you don't have clear title. One of the definitions that they could mean is that there isn't a clear title chain for this property. This is especially significant when we're dealing with a loved one passing, because if a loved one has passed away, then they are unable to create a deed in order to convey the property, whether it be to their children, their spouse, or to whoever they want to name in their will. There's no way for them to create a deed in order to do that. So in order to gain clear title, you need some sort of written evidence that shows how that property passed. And in Texas, there's a couple of ways to do that. Now, y'all already know I'm going to tell you, you need to talk to an attorney to find out which way is the best way for you to handle this process. So if this loved one has passed away and unfortunately didn't have a last will and testament or a trust as part of their estate plan, then you may have three options that can be taken in order to make sure you get clear title. One could be an affidavit of heirship, which is a non-judicial process. It's just a sworn statement of two disinterested witnesses stating the family history, the marital history, and what property was owned. Using this document takes into account that you are following Texas law on how the property passes. It isn't just, oh, whoever wants the property can take the property. There's actually law that says who gets what, dependent on the situation of the decedent when they died. You may also have the option of a small estate affidavit. However, small estate affidavits can be quite difficult to get approval for. They are a judicial proceeding, so you will need a judge to prove an order for it. And finally, you can get a determination of heirship, which is also a judicial determination. It usually involves an investigation done by the court to make sure that there are no unknown heirs or anybody that's been left out of the application. This is a process. You do have to go through the court, and it is advisable that you have an attorney. If your loved one has passed away and they have a will, you may have the option to use a monument of title. And this is where you can get a court order from a judge that states that the will is valid and the provisions in the will that tell how the property should be distributed are now valid and true. Now, sometimes these simpler probate options and non-probate options are not available because there is a need for administration. If your probate estate is in need of administration, then either an executor who was named in the will can be appointed or an administrator can be appointed. The benefit of having an executor or an administrator appointed can be the ability for that person to be able to step in the shoes of the loved one who's passed away and create the deed that needs to be created in order to create clear title. For example, if there's a loved one that's passed away, they had no will, there's an administration and an administrator is appointed. The administrator can create a deed that says, based on Texas law on how this property should pass, this property now passes to these listed heirs, and can actually create a deed that shows that conveyance and file it into the property records of the county clerk. So what's important to know is that in the event that you have a loved one that passes away, you should always talk to a probate attorney before you take any action to make sure that you are choosing the best and optimal way in order to take care of the estate and make sure that property passes properly.